Hello, and welcome to another Institute for Sound Public Policy podcast. I am your host, Kevin Lynn, and I'm also the executive director of the Institute. Now, I'm joined by a great guest who's been on our show before, attorney, tech worker, John Miano, who really needs no introduction, but John, welcome to the show. How you doing?
Hey, it's great to be here, Kev, as usual.
Well, it's great to have you back because we're going to be discussing something that's still in the offing, and it is the Supreme Court of the United States has decided to hear a case called Loper Bright versus Raimondo.
Now, that's it.
Yep, that's it, and it's about it's about fisheries and issues like that, but it's going to have wide-ranging implications. For those of us here looking to restrict immigration and bring some sanity and legality and lawfulness to our immigration system. But what I'm thinking, John, you and I could talk about the case itself, but Dinesh D'Souza this weekend talked about it, and I thought he gave a really good overview in terms of the generalities of the case that are, help lay people like me understand the background. So it's about 4 minutes. I thought I'd play the Dinesh clip, and then you and I could talk about the implications for immigration. What do you think?
Sounds great.
All right, here we go, and we are rolling.
So the case, although it focuses somewhat narrowly on the issue of fisheries and the Marine Fisheries Agency of the government, and but the implications stretch to federal regulations in environmental areas, federal regulations over guns, the ATF, the FBI. Think of the kind of plethora of agencies of the federal government, and all of them make detailed rules. And yet, when you look at the congressional statutes that have authorized these agencies, you can very well ask yourself, where did Congress give you the power to do this? And the federal agencies typically reply, well, Congress gave us sort of a general power to, quote, look after the environment, or gave us a general power to manage fisheries, or gave us a general power to administer law enforcement. And then we took it upon ourselves to have all kinds of technical experts and administrative judges. And then even if people question our decisions, what do? We refer it to an administrative judge inside of the Fisheries Department or inside of the ATF. So these people can't even really go to court, because when they go to court, the judge will say, well, it's not our job to second guess these federal agencies. This federal regulation, although you can dispute it, is a reasonable interpretation of the broad congressional statute. And so we, the courts, are going to stay out of it. Now, the reason that the courts take this stance, which is, you may call it a deference to the power of the administrative agencies, is because of a decision going all the way back to 1984 called the Chevron decision. The decision was Chevron versus Natural Resources Defense Council. And the meaning of that decision was that the federal agencies were successfully able to argue to the court that courts should not attempt to adjudicate their rules. Federal agency makes a rule. Let's say, for example, that if your land adjoins a wetland, then the EPA has the right to seize your land or fine you or conduct all kinds of operations on your land, whether or not you agree to it. And it's because even though your land is not a wetland, it, quote, adjoins a wetland. All right, so that would be an example of a rule. And then a guy gets, let's say, fined for some EPA rules on his property, and his property is near a wetland but doesn't actually touch the wetland. So the guy sues, and he goes, hey, adjoins doesn't mean that adjoins means that my land is actually on the wetland, or it is so connected to the wetland that the government can't regulate the wetland without regulating what's happening on my property. But my property happens to be half a mile away. And yet, in their view, it does adjoin the wetland because the same kind of birds fly over both properties. And in the past, citing Chevron, the court would rule, well, I guess we can all disagree over the meaning of the term adjoins, and we think that the EPA's interpretation is reasonable because exactly wildlife and so on exist on both properties. The one is not sort of separated from the other in terms of an ecosystem. So we're going to let the EPA decide whatever it wants. This is really the issue that went before the Supreme Court.
All right, John, what did you think of that?
Well, I think it's a good summary, except one disagreement I have is that Dinesh talks about accepting reasonable interpretations.
Mm-hmm.
In reality, under Chevron, what it's become is possible interpretations.
Oh, that
No
leaves, you talk about deference, that's like a whole lot more wiggle room, isn't it?
Yeah. So, for example, let's say Congress gives an agency the power to regulate bridges, okay? Mm-hmm. Well, they decided that they're going to start regulating roads as well. Well, then you'll get a federal judge that'll say, oh, but under some, interpret definitions of the word road, a road can be viewed as a bridge to two places, so there's a possible interpretation and then gives deference. So the level of deference is much broader than what I think Dinesh has said.
Yeah, now,
and more problematic.
In two cases, one of them, it's WashTec versus Department of Homeland Security that you were the lead attorney on, and it actually it was appealed to the Supreme Court. They chose last year not to hear it. But this is a case that's predicated on deference, correct? It's where a government agency essentially dreamt up an immigration program. Isn't that correct? You want to tell us a bit about that, John?
Well, yeah, and this illustrates the problem with this overenthusiasm about this Supreme Court case, in that in the WashTec case, what happened is the over a dinner party, DHS worked with DHS Secretary Chertoff, along with Microsoft and industry lobbyists, created a regulation in secret which turned out to be the largest guest worker program in the entire immigration system. And what they were doing is allowing aliens to remain in student visas for years after they graduate. Okay. Meanwhile, the student visa statute says that these people are supposed to be solely pursuing a course of study at an academic institution.
Right, and because, John, that's what I think you argued so effectively up the chain. And yet, they went back to the deference that the agency, the Department of Homeland Security, isn't that correct?
Well, yes, but even here, in this case, it went beyond this type of deference, in that the D.C. Circuit held that the non-immigrant visa statutes cease to apply as soon as an alien enters the U.S. And once that happens, the alien state is governed entirely by regulation. So the D.C. Circuit has basically stripped power from Congress and handed it to an agency. And they did it outside of this Chevron framework we're talking about. So even if we had this new ruling here, this wouldn't affect it. But it's also interesting that 2 years ago, we had another one of these Supreme Court decisions on agency power, West Virginia versus EPA, which deals with something called the major question doctrine, which said that major issues have to be enacted by Congress and cannot be deferred through a statute. Okay? And clearly the largest immigration system,
which is optional practical training, OPT,
right, would fall into that, and the D.C. Circuit just ignored it. I mean, they don't even mention their opinion. The dissent does, but the opinion, and so the problem we have is, what I think people don't appreciate is in the courts, the law is whatever the judge says on any particular day. Okay.
Okay.
Most judges are good, but there are enough bad ones, that are completely inconsistent, don't follow precedent, that contaminate the entire system. And what is supposed to happen is, at the district court level, they do decisions. Then the courts of appeals are supposed to overturn the outliers in the district courts, and then the district courts the court of appeals uses panels. They're supposed to use the full court to address opinions that are outside of the precedent, and then the Supreme Court is supposed to bring uniformity below all the courts below, and that simply just doesn't happen. They don't manage the system. And so law is not like Newton's third law, Newton's second law, where you get predictability. The American law is in chaos, which generates more and more litigation. And in fact, we've kind of had this joke. I testified for the Senate Judiciary twice on the WashTech case, and it illustrated how the courts were just generating more work for themselves. And the staff members of the Judiciary Committee were telling me, every year the Chief Justice tells us that we need more judges because we're overworked, and then we see cases like yours where they're just creating work for themselves. And I literally fall into that category that we could, if we doubled the number of judges in the federal courts, we would double the amount of work, and we'd increase the amount of chaos in the law. So we have quite a mess right now. The other important thing to realize, though, I don't think the public does, is that almost all law is now coming from these regulations. It's not coming from statute. Congress enacted something like 25 statutes this year. There were thousands of regulations put out.
And you're talking, when you say regulations, you're pointing directly to the Federal Registry, where these rule changes are published. There's opportunities given for public comment, and they pretty much just rule in favor of the agency. Like, we responded to 4 or 5 rule changes in the last year.
Well, and the also growing problem is sometimes they just don't give notice and comment. So that's another area of discretion. I'll give you again the WashTech case. We had a secret lobbying. The rulemaking was done entirely in secret. Nothing happens. And the law says that when that happens, the courts are supposed to set the regulation aside. Court didn't do that. The district court said, "Oh, just keep doing what you're doing and do some meaningless after the fact notice and comment." And so that takes away any incentive for the agencies to do notice and comment. In fact, there are a huge number of regulations that come out without notice and comment. There are at least 30 regulations authorizing alien employment that were done without notice and comment. There are even regulations authorizing employment on tourist visas from 30 years ago made without notice and comment. So they're not. It's an aristocracy. We don't have a democracy in America anymore. Okay, our Congress is just a figurehead. Almost everything is coming from. Almost all of law now is coming from these unelected bureaucrats who just run amok. And add to that, the American people have no influence over them. Because you look at your congressman, he may be influenced by the big money, but eventually he has to go to your vote. In addition, your congressman is probably. And in addition, your congressman is going to be having town meetings in your district where you can go and yell at them. When these things are made by bureaucrats, you have to be in Washington to do this lobbying. Okay, you have to be. You can't do that. You can't do regulation lobbying if you're not in Washington. And the average citizen doesn't have anything to offer the bureaucrats, because these bureaucrats are looking for their post-administration consulting jobs.
Wow.
So what the people that control the this system are the big money, big business and whatever. And I think it's funny watching, you'll see in the news, the New York Times, in our big corporate controlled media screaming about this, the dire consequences of this case if Chevron is overturned. what it really means is their power will be losing. You know, the regulation benefits big business. So I'll give you an example. Toilets are regulated up the wazoo.
Okay.
Well, I mean, stupid. Well, the toilet industry loves the regulations because it keeps competitors off the market.
Yeah,
And you
absolutely.
can pick it.
It's a barrier to entry.
Yeah. So you go to any product that's heavily regulated, and most products are, it seems. I mean, refrigerators, anything that's heavily regulated. Those regulations are done by the industry and the people people in power. And so basically, I mean, like, we have no democracy in America right now. It's completely gone. It's completely gone. So, you know, when people say, you know, January 6th was an attack on democracy, that's baloney. There's no democracy left for them to
for
attack.
them to attack. It's like,
You know,
I used to laugh when people would say, "Oh my God, that's sacrilege." I'm like, you talk of our Capitol building as it's some kind of sanctuary, some kind of temple, something that, and it's essentially a whorehouse where where all its inhabitants are multimillionaires and not responsive to the needs of the people that voted for them, but the special interests.
Yeah, I mean, and the problem is everyone involved is, has the opportunities for the grift. You know, you get on the Supreme Court virtually penniless, you get that multi-million-dollar book advance, and you're a super millionaire. You know, better than winning the lottery. So, you know, when you really look at it, you know, the Supreme Court has no incentive to crack down. No one has any great incentive to crack down, and the people are suffering, but they don't seem to know why. And this whole system, this administrative system, needs to be thrown out, tossed in the garbage, and shredded. And what I'm fairly certain is that this new case, even though it's been widely hyped, is not going to do that. Mm-hmm. I think the judges are just going to do that. And in fact, the immigration cases you described were all decided without Chevron. I think that the courts are preparing to how they can do their crazy rulings without, even in the face of this Chevron doctrine being overturned.
Going back to WashTech, which is the optional practical training case, the law is pretty much set in stone. When you come here as a student, one, you have to say you plan to return to your country of origin, and then two, you are here just to study. And somehow that got contorted and bastardized and turned into the optional practical training program, which gives someone who, like in the case of someone who gets an advanced STEM degree, science, technology, engineering, mathematics, they can get a 3-year work permit to work anywhere in the United States and at any wage the employer sets, because it's a optional practical training program. I mean, but the law is there. How could these judges have not? Again, I guess it gets back to what you were saying earlier, but John, in your words, why couldn't the judges see this?
You know, it's not the answer they want to get. What I think you're very seeing is what I would call outcome-oriented jurisprudence, where you pick the outcome and you make the law fit. And like in the case of WashTech, in order to make the law fit, they had to make a complete hash out of the law. So
interesting.
One of the principal holdings of WashTech is that that the terms of visas, non-immigrant visas, cease to apply once an alien enters the country. So if a person has come in on a tourist visa, they can switch to a student visa and it doesn't apply. They in theory then can apply for an H-1B visa and not have to do the labor condition application.
Oh my God.
There's a T visa that only applies if you're in the United States already. But under WashTech, the terms of the T visa don't apply after you enter, and they don't apply before, so when do they apply? So
John,
what
do you
have
want
is judges.
our audience may not know what a T visa is?
T visa is a human trafficking visa, one of these things.
Ah, okay.
But it deals with human, and so you can get in. So the T visa is completely nonsensical under this new interpretation of the statute. In fact, I mean, basically every visa is now nonsensical. So what we've done is thrown the door open to DHS creating new regulations and more litigation, because you can't. This was a statute. The non-immigrant visa statute were one of the few places in the immigration law where an average citizen could read the statute and understand what it means. Now,
Right.
no one, I can't even look at it. I don't know what it means anymore, because it's just, nothing makes sense anymore. Another key holding was DHS can allow alien employment on any visa that's where the employment is reasonably related to the visa. Again, I don't know what that means.
Reasonably related.
Yeah, and that's something completely invented by the courts. It's not, the term reasonably related doesn't appear anywhere in the immigration statute.
Correct?
It's not anywhere in there, and so it's entirely judicially. It's the judges making new, rewriting the immigration statutes for us.
And what you said then, John, they're pushing. They know the outcome they want. They're pushing that narrative regardless of the law. This is absolutely amazing. The thing is, these laws were designed, as flawed as our Congress can be, immigration law was designed to protect the American worker, the American citizen. And a great example of how it's not is there was an article a couple weeks ago in the Wall Street Journal. And when you look at all the hirings and all the firings in computer, science, technology, engineering, math, there were a net 700 jobs created in 2023. Now, in 2024, we're going to have 100,000 kids graduate with STEM degrees. We're going to have 85,000 H-1B visa workers join us. We're going to have, 20,000 some optional practical training people join us, chasing 700 jobs. This is insane.
I mean, no one's looking out for the average American person. And even worse, there's even talk now that Congress is in the current deal over the budget in Ukraine, and that they allow H-4 workers, H-4 aliens to work as well.
Right, that's the wives. That's the spouses of the
wives, spouses, and children. Even I've even heard it described as allowing the children too. So no one is looking out for the average American citizen. And it said we have in the immigration system. They said there are about 30 or so regulations authorizing alien employment that have no basis in the statute. That system of immigration is probably larger than the system authorized by Congress. And I don't know if we want to get into another topic, related topic, but that is of standing. We have one of the things that the courts have done to protect the corruption in the agencies is the doctrine of standing. So you have to basically, every lawsuit against an agency is two steps. You have to litigate that you have standing, which alone can take 5 years. And then you get to litigate whether you, the merits of your case. And what this has done is created a defense to every agency action. No matter how absurd, how unlawful an agency action is, the agency can always argue that you don't have standing to bring the lawsuit. And where this comes in is in the closing days of the Obama administration. I mean, January of 2017, they put out something called the International Entrepreneur Rule. And what this does is allows to bring aliens who are, quote, entrepreneurs to come into the country and work on parole. Now, parole is the legal fiction that you've come into the country, but you actually haven't been admitted into the country. and it's supposed to be used for things like to bring people in for emergency surgery who wouldn't otherwise be allowed to the United States. So, when the examples give, it's supposed to be for short-term, case-by-case, bringing people in. But the Obama administration has standard this entrepreneur role. The reality is no entrepreneur would come in to the United States on parole because there's no path to citizenship or whatever. So this never, I don't think anyone ever got a work permit under this rule. Okay. But on the other hand, no one can challenge it because you have to show injury. Well, how do you show injury when to a rule that no one has come in on? Or, how do you show injury when they're bringing entrepreneurs into the country? Well, then suddenly 6 years pass, and now we're in the Biden administration, and the Biden says, oh, we're going to bring in 100,000 people a year on parole from different countries and give them work permits, because under this regulation made 6 years ago that now the statute of limitations is expired, we're allowed to give them work permits. And again, so we have this broad interpretation of parole. Again, parole is defined. Congress sets out in the various reports on the Immigration and Nationality Act what the kinds of things expected. It didn't expect to hand out 100,000 of these things a year to people just crossing the border.
Oh, yeah, John. If you're an illegal alien and you get on the CPB app and you say, "Hey, I'm coming in at this port of entry," you're going to get a work permit. You're going to get. It's insane. And again, like you said, the intention was that parole was going to be used infrequently and very specifically. Like, as you said, you're coming in for 2 weeks to give testimony or something like that. Or, you need to go to hospital, things like that. But they're just abusing it. And this is why I think Congress is absolutely justified in impeaching our Department of Homeland Security Secretary Alejandro Mayorkas. I mean, we cannot impeach that guy fast enough, don't you think?
Oh, I mean, making Mayorkas the DHS Secretary is like putting Reinhard Heydrich in charge of race relations. I mean, you basically got someone who's intent on destroying the country in charge of protecting the country. It's just amazing to me how this could happen. How one party just standing by while he's doing it. Of course, on the other hand, I would expect to see Mr. Mayorkas in a lot of Trump ads over the coming.
And we're back. We had some technical difficulties there. John, how's your sound?
I'm back, I think.
You are back in the black. Yeah. Right on. Well, hey, we were talking about Mayorkas' impeachment. And every email, every conversation I have, I end it with the phrase Mayorkas impediendus est. And it's Latin for Mayorkas must be impeached. And it kind of goes back to a phrase that was used after the Punic Wars. Cato the Elder would end every speech of his with, "Consider that Carthage must be destroyed." And I say again, Carthage must be destroyed. And in this way, Mayorkas must be impeached because it's just been an absolute disaster for us.
Well, in a sense that he's the Republicans' best friend for the election coming out.
Yeah, I think so. All the polling, John, not just like, some that veer more to the right, the Harvard polls, immigration is now the #1 issue in the country.
Yeah. I mean, look what happened is that, Governor Abbott just sends a small fraction of the illegal aliens that are being dumped on Texas, and, and sends them to, New York and Chicago, and it's a catastrophe.
Oh, yeah.
Now, just think
about it. Yeah, like 8.8 million it's believed have come across the border in this invasion. And, New York's received about 130,000. That's it. And they're screaming uncle, but they still want to be a sanctuary city. Go ahead. I cut you off, John.
Well, I was saying that you just think that they're getting a small part. You can see what a big effect is being happening on these border states. I mean, only a small fraction of the invasion is being passed on to these sanctuary cities in the Northeast, and they're in panic over what they're getting. So just imagine what's going on in Texas. What they're being hit with.
Absolutely. I'm actually going to go back to the border next week. I was at the border over the summer for a week with Operation Burning Edge. I'm going to go back next week and see what's going on again, because I think it's important.
Yeah, well,
I mean, I have to be able to speak from a experience, not just an authority, but part of that is experiencing what's going on at places like the border.
Well, at least Mayorkas has secured his post administration job. That you can bet the cartels will be jumping over each other to hire their best friend. I mean, no one has done as much for drug cartels as Alejandro Mayorkas.
I don't think so. He's going to be a difficult act to follow, but it'll be. I really hope Congress impeaches him. I doubt that it'll get through the Senate, but for me, it's like for the rest of his life and throughout history, he'll have something of a scarlet letter attached to him. Right. And when we look at the disasters that we're going to spend the next 10 years reeling from, we can point to one man, Alejandro Mayorkas.
Yeah. Well, plus the impeachment, we'll get to see, who the enablers are in the Senate of this craziness. And we'll get to see people down black and white who is causing basically it's treason to America. Who are the traitors? And it appears that we must have elected traitors. Who are going to put up with this. I mean, what Mayorkas is doing is treason by any measure. This is complete malfeasance on a scale. I don't think anyone has seen anything like this in American history, certainly.
I mean, I certainly never would have imagined. I knew things would be bad, but I never imagined that they would get this bad. When I like, the Heritage said, 3 key takeaways on the impeachment is, number one, Department of Homeland Security, Mayorkas has intentionally instigated an unprecedented border, national security, and humanitarian catastrophe. Number two, Mayorkas has violated his oath of office, abused the powers of his office, and betrayed the trust of the American people, endangering the constitutional republic. And third, his misconduct is so reckless, so irresponsible, and so serious that he should be impeached, removed from office, and disqualified from holding any further office.
Yeah, that sums it up pretty well. And I don't think we've seen this level of incompetence by thinking you have to go back to like the Vietnam War to see this kind of incompetence before. That so I'm just saying it's probably not unprecedented, but if you look at the conduct of the Vietnam War, it's the same level. And what I think you're going to see is that Mayorkas is going to be the guy that gets Trump reelected.
Yep. Yeah. I mean, they certainly pushed immigration to the front once again. So there we go. So, John, we talked about your cases that were appealed to the Supreme Court. You didn't get the satisfaction I think you deserved in terms of being heard. Perhaps there'll be a time in the future. We talked about the impact that if the Supreme Court rules on Chevron, you didn't think it was ultimately going to be that impactful, because what's impacting immigration law is not Chevron, but it's a total abuse of the law, or just waylaying the law. Is that correct?
That's basically it. I mean, that you can interpret the law just as crazily without Chevron. You just say the same thing, but don't use the word Chevron in your decision.
Okay. Well, John, this has been great. Now, John, you are a hero to the underdogs out there. I mean, no attorney I know is sticking up for working Americans the way you do. How can people find you, reach out to you, and help you?
Wow.
Help you help others. I'll put it that way.
Well, I guess the best way they help me is by helping you. You know, because you guys provide organization, you know, to take on these things. You know, I have to basically operate as an individual, but personally, you guys provide the infrastructure like the telephones and the printing
Right.
to make a lot of stuff happen.
That we do, and I appreciate that, John. And I'm going to put put up our website, go to our donate page, and know that. Oh, you have a visitor behind you, John.
Oh no!
We have another subject matter expert about to weigh in.
I picked this spot to try to be away from that. Well, I guess,
they found you.
I guess there are a lot more of them around me that you just aren't on camera.
Great. Well, again, I'll put up a link to where they can donate to us. Also, if you enjoyed this video, felt you got something from it, be sure to give it a thumbs up. Also, subscribe so that when future videos are done, you'll be notified. John, always a pleasure. Thanks so much for joining me today.
Oh, it's always great, Kevin. Great place to vent the issues.
Yeah, there you go. Take care, John, and take care, everyone.